Hello everyone, this is Sachin Sawant, your UK immigration lawyer. Today I'm going to talk about a recent development that we have been observing. Individuals who have been refused a status under the EUSS, EU Settlement Scheme. Preferably, usually it is a pre-settled status application, usually a late application which has been filed and it has been refused. And the main basis of that refusal is that no proof of residence in UK residence before 31st December 2020. That is before the end of the transition period. If there is no evidence that the individual was living in the UK and that application has been refused by the caseworker, then in such cases, as per the EU settlement scheme, so I'll explain the law and I'll explain what is happening in practice. So if such an application is refused, there is a right to administrative review, and subsequently there is also further right to an appeal to the tribunal. And during the pendency, during the processing of either the application or usually not the application because it is refused, but during the pending, when the admin review, AR or appeal, if one of these are pending, as per the EUSS, EU settlement scheme, the applicant is allowed to travel outside the UK and freely travel back in. This is different from non-European national area. British immigration rules is different, but under the EU settlement scheme, so it is called as EUSS. If you have a pending appeal or AR, administrative review, then you can travel. However, in practice, there is another guidance on the basis of which individuals have been denied entry. We have had instances. I'm a member of Immigration Lawyers Association, and many of the lawyer community has experienced this, that the clients have been refused entry. So this is a case where, say, Mr. A is the applicant. He applied for pre-settled status. It was refused on the basis that he did not provide enough or some satisfying evidence to the caseworker that he resided in the UK before 31st December 2020, and it is refused. He filed an AR or an appeal or one after the other. So whatever he has done, and he leaves the UK, he comes back to the UK. The immigration officer has a right at the port of entry, so airport, any seaport, anywhere the individual is trying to enter. The immigration officer, so immigration officer, let me just write, so I call him the IO. The immigration officer can question him at the port of entry, say the airport. Let's say he's entering at Heathrow Airport. They may ask him questions to establish why is he entering the UK. However, if they have a discretion, or rather they have the instructions as per the border guidance, UK border force guidance, they have a separate guidance internally to opt for their own operations. They can ask the questions to the individual and decide not to allow that person to enter the UK. This has been observed in practice right now. Earlier it was not that much. Right now the EU settlement scheme applications refusal rate has gone up. It's quite a long this scheme has been operating, and now usually the tricky ones, the complex cases, are getting in the lot of applications. So the immigration officer may ask the questions, and if that pre-settled status application has been refused for this reason, that the individual was unable to prove to the caseworker who looked at his application and refused it, that he did not have residence before 31st December 2020, that is the end of the transition period, then he may refuse entry. There have been instances where individuals have been returned back, they have been given letters, they have been put back onto flights, and they have been returned at the airports and ports or other ports of entry. So we just want to let everyone know, warn everyone that yes, if your EUSS application has been refused, especially if it is a pre-settled status application, and the basis of one of the reasons of the refusal, or the main reason for the refusal, is you did not provide us enough evidence to show that you did begin your residence before 31st December 2020, then you are highly likely to be refused entry. It is highly likely. So be careful, be aware, avoid traveling if possible, and that is our advice. That is what I would suggest. So I just wanted to share this practical experience that recently has surfaced now. If you need specific advice about your your immigration situation, your refusal, appeals, we deal with appeals, etc., everything under the USS, uh, and other areas of immigration as well. So you can book a consultation with us. There will be a link down below, or you can go to a website and you can book a consultation wherein we can take the details of your specific case and we can advise accordingly, plan out what are the different options, if there is any other option to have another application in, etc., under the British immigration rules or anything else like that. So yes, so we just wanted to share this information. Secondly, if you do like this video, do subscribe it. It will help someone, because I know people are stuck in this situation. I have had consultations, so from my own experience, from other lawyers' experience that we share, yes, there are people who are stuck or who would get stuck. So their applications refused and they feel that they can just leave the UK, and on returning they may have issues. So it will help someone somewhere not getting stuck at the border and being returned. So yes, do like this video, subscribe to our channel. If you subscribe, YouTube will throw this video to others as well who are in need. There are many people in need. US's applications are being refused. So it is quite a grave matter. So please do like, write any comments. If you don't like this video, you can dislike it as well. Do subscribe to our channel. That is very, very important, and that's how this video goes to other people who are in need, who may search similar terms like USS refusal, USS appeals or something. They would get some information. It would benefit them. Thank you very much for watching, and bye.